Good afternoon, everyone. This is Kimberly Richardson here, and I'm with Jordan Schwartz, and we will be presenting today on the changing landscape of non-compete laws. We thank you for joining us today. This is one of our webinars that is associated with a series of webinars that we have, and we will have a schedule at the very end of this presentation so that you can see what future webinars we have in place and in store for you. Yeah, I want to turn it over to one of the partners at our firm, Jordan Schwartz, to introduce himself.
Thanks, Kimberly. It's nice to be here today. I think this is the first webinar I'm actually doing in our 2024 employment law series. For those of you that don't know me, I've been here at ConMaciel since we founded almost 10 years ago. And I do all aspects of employment law. I do a lot of non-compete work. Other than that, I do a lot of ADA work, discrimination work, and all sorts of counseling on employer-employee issues, and I'm looking forward to talking to you about all the very interesting developments we have in the world of non-competes.
Thank you, Jordan. And I am Kimberly Richardson. I am of counsel with ConMaciel. I have almost 20 years of experience handling issues related to health, safety, labor, and employment in the firm context, federal government. I was in-house for a while. I am also going to be assuming a full-time professor position. I currently teach at Drexel's Law School, and I will be assuming an assistant professor position at Wilmington University School of Law starting in the fall. So I'm so excited to talk to you about some of the new and burgeoning issues that we have here today. And let's go ahead and jump into it. Thanks, Jordan. So today we are going to give you an overview of the landscape associated with non-compete agreements. It's so important that we not just talk about the FTC proposed rule and the final rule and what might happen as a result of that rule, but we give you some context in which this rule was promulgated. One of the reasons is that this rule may be knocked down, and so we may be left with existing state and federal restrictions and the general common law associated with non-compete. So we'll start off with a brief primer, a history of the state and federal restrictions and kind of how this FTC proposed rule came to be. We'll talk about the FTC final rule, some of the challenges, and what to do until the dust settles, the key takeaways, and some recommendations on hiring and terminating people with non-compete. Next slide.
And just there's a chance with the in-depth discussion of the FTC final rule that the hiring and terminating people may be very brief, but we did want to at least mention it, as Kimberly said, because it still may be relevant if the FTC rule goes away or gets enjoined in some way, shape, or form.
That's a great comment. Thank you, Jordan. So before we, as I mentioned before we dive into the Federal Trade Commission's final rule, we wanted to provide a brief primer on non-compete agreements and those key legal developments that preceded the FTC's action. These non-compete agreements they're also called covenants not to compete, have been around for a very long time, but the legal landscape has been essentially significantly evolving in the last decade. And this evolution has been really a reflection of changing public opinion regarding fairness, worker mobility, transparency, and the debate around these non-competes centers essentially around two competing interests, just general interests. On one hand, you've got the interest of the employers in protecting their business assets and investments, and on the other hand, you've got the rights of employees to freely pursue economic opportunities. And so, as I mentioned, we're going to start off with this primer, but it's going to be so important to take note of some of these things because that FTC rule has already been challenged. And in case the court strikes that rule down, it's going to be important to, focus on the basics. What exactly do we mean by an enforceable non-compete agreement? So a covenant not to complete or a non-compete agreement is a restrictive covenant designed to prevent workers from competing with a prior employer. So this may be directly or indirectly, and it's usually for a specific period of time and within a certain geographic area. And these restrictions may apply when the person remains employed and or after the person's employment has ended. Traditionally, the parties enter into these non-compete agreements before the worker begins his or her employment. And at that time, the worker should be made fully aware of what agreeing to this employment means in the future. He or she must forego certain opportunities, for example, in the future for a specific period of time if he or she takes on this type of employment that involves a non-compete. And so when I say what these opportunities are, like these future opportunities that you might be forced to forego, that might include going to work for a competitor, starting a competing company, or developing competing products. Next slide. So in order for a non-compete to be enforceable, it must have three features. It must be supported by consideration at the time it is signed. It must essentially protect a legitimate business interest of the employer. And then finally, it must be reasonable in scope, geography, and duration. And I'll start by tackling the consideration issue. A court will scrutinize non-compete agreements to confirm that there was consideration at the time the agreement was signed. In other words, there must be some sort of legitimate bargain for exchange. All the parties to the agreement must be obligated to do something or must be obligated to forgo something. So essentially, think of the agreement as this basic exchange. I will give you this thing and you will give me that thing. Essentially, the courts will ask, what is the this and that of the exchange? As such, it's not uncommon for contract drafters to explicitly identify a specific portion of an employee's compensation or some other benefit that constitutes consideration for a restrictive covenant. The goal being to proactively address any questions about what the consideration was that was used to support the non-compete agreement. Now, the inquiry about consideration is different when you're talking about new employees versus existing employees. The offer of employment is generally considered adequate consideration when a restrictive covenant is executed. So as part of the original agreement. In other words, I will give you an opportunity to work for me at this salary and with these benefits. And in exchange, you will agree not to work for a competitor for a certain period of time if you leave this job. That's the basic exchange with new employees. Now, the questions and considerations become more complicated when a company tries to enter into a restrictive covenant with an existing employee. These workers are already working. So merely offering the person an opportunity to continue working the same job with the same benefits may not be considered by a court to be adequate consideration to support a new non-compete agreement with an existing employee. So I'm not saying in every state you have to offer more. In some states, a state may say for an at-will employee, continued employment may be sufficient because continued employment is not guaranteed for at-will employment. So in those limited jurisdictions, though, the rationale kind of goes like this. There's no guarantee that you will have an opportunity to work for me tomorrow. So if you come back to work tomorrow, then you must sign this agreement in order to work with me. In other states, though, and the best practice is that even with at-will employees, regardless of the length of employment, you should really offer some additional material consideration in exchange for a worker's agreement to forego future economic opportunities if that worker is currently employed. And just know that consideration may often come in the form of increased compensation, like a raise or increased base salary, a signing bonus, or eligibility for some other new bonus. But it need not be monetary. So what does a non-monetary consideration look like? It could be a promotion with a new title, access to confidential and trade secret information that the workers otherwise wouldn't have access to, additional job training. So for example, I will pay for your MBA if you agree for the next 2 years not to compete with my company, if you so choose, if you choose to leave at any point in time. Even for at-will employees, the additional consideration may be, for example, fixed term. So I could fire you for any reason as long as it's not an illegal reason tomorrow. However, if you agree to this non-compete, you get guaranteed employment for the next 2 years. So those are some examples of non-monetary consideration. Next slide. So as I mentioned before, there's 3 features that non-competes must have in order to be enforceable. Consideration is just the first one. The second one is that the non-compete should only be used or must only be used to protect legitimate business interests. Now, regardless of how well a non-compete is written, courts will only enforce it. Courts will not enforce it unless an employer can identify a legitimate business interest that the restrictive covenant seeks to protect. So courts have been reticent to exclusively define legitimate business interests, like a all-encompassing definition of what this means. Instead, they typically recognize specific legitimate business interests based on the totality of the circumstances surrounding the agreement. Now, conversely, courts have identified certain business interests that are not protected. So, for example, legitimate business interests don't include merely protecting an employer from any type of competition. In addition, employers don't have an interest in preventing employees with just general knowledge, general skills, general training, general experience from competing with a prior employer. So, for example, a manager at Burger King may opt to leave that position to become a manager at Starbucks. Just general information, knowledge, and skill. There's no guarantee that you can protect yourself from competition of that sort. Next slide. So as I mentioned, the courts have identified or recognized legitimate business interests. Those include trade secrets, intellectual property, customer lists, methods. These are a lot of this. You might sense a theme that it's specialized knowledge. It is an investment that the employer has made in their business, and to prevent this sort of information, to prevent that sort of investment from being used against you in competition immediately after a person leaves their employment. Next slide. Now, in the 3 factors, or those 3 features, consideration, legitimate business interests, the third one is reasonable scope, geography, and duration. So in order for a non-compete to be enforceable, it must be reasonable in terms of its scope, geography, and duration. What this means is that the restrictions may be no broader than what's necessary to protect the employer's legitimate business interests. Courts may deem a non-compete agreement unenforceable if it's overly broad, and that may include, for example, having it extend for too long of a period of time, in part because these agreements may create significant obstacles for unemployed workers. So, for example, if the geographic coverage is too broad, a worker may feel as though he or she must leave the state, or leave their home, or a significant period, a distance between their current location and where they need to go in order to get gainful employment. So the question becomes, is it fundamentally fair to enforce this agreement? Is the scope, geography, and duration limited and reasonable, such that if the court enforces this agreement, it's not going to be unfair to the worker who's subject to it? For this reason, non-compete agreements must be clear. They must be conspicuous. They must really give the worker reasonable advance notice of the restrictions and what's covered. By doing so, an employer can better demonstrate to the court, or whomever they need to, that the worker knew exactly what he or she was getting into when they accepted this job. He knew that by accepting this job with this non-compete, that these were going to be the conditions if he left. Next slide. Now, there are some industries and jobs where it's generally considered to be against good public policy to enforce a non-compete. For example, lawyers. Lawyers are the legal field is just one such category, and this is because the attorney-client relationship is so personal. If a lawyer opts to leave his employment and go elsewhere, clients should be allowed to follow that lawyer because that's a personal relationship that they have. The same analogy applies to doctors and patients. Next slide. So we've talked a lot about the common law, these general principles associated with non-compete agreements. And I want to emphasize that non-compete agreements, the law surrounding that is primarily governed by state-specific law. We're talking state common law, statutes, and regulations. Again, these things are state-specific and specific to the facts. Courts evaluate these based on the totality of the circumstances. And this means that the jurisdictions, the place where the person performed the work, the place where the agreement was executed, the dates of the agreement, the title, the salary, and the responsibilities of the worker, the industry in which the worker worked, the duration of the agreement, the purported legitimate business interests that are covered must all be considered in order to determine whether or not you've got a strong, enforceable non-compete agreement. And even if you have a strong non-compete agreement, it's also important to know that a lot of courts disfavor these and closely scrutinize these agreements because they're worried about interference with good competition, the potential adverse impact on innovation, and whether or not the court may be hampering an employee's ability to pursue better employment opportunities elsewhere. And so you will hear constantly about this balancing between protecting the employer's legitimate business interests and allowing the employee to seek gainful employment and not be unreasonably and unfairly hampered from doing so. And a lot of the restrictions are found within state laws. Next slide. So over the last decade or so, we've heard what I like to call just like this anti-non-compete chorus getting louder and louder from state legislators. And more states have become concerned about the number and the breadth of non-compete agreements. For context, historically, non-compete agreements were mostly associated with high-paid, highly skilled workers who have some sort of specialized knowledge or access to confidential and proprietary information. However, these agreements have been used broader and broader and encompass more lower skill, lower wage workers, and with questions about whether or not they have any specialized skill or knowledge or access to proprietary information. And as such, because of this broadening of the use of these agreements, there's been more and more states that are concerned about workers being unable to leverage their skills and freely switch jobs for higher pay or better working conditions. And they're frankly also concerned about the potential adverse impact that these agreements may have on entrepreneurship and innovation. A person may be a skilled scientist who feels as though their talents are stifled with a particular employer and seek to start a new business or company, and that non-compete may keep them or make them hesitant about doing so. And since roughly 2018, a number of states, I don't recall the actual number, I want to say roughly about 15 states, including Washington, D.C., have enacted laws that impose some sort of limitation or restriction on the use of non-compete agreements. For example, California, North Dakota, Oklahoma, and Minnesota have sweeping bans on these things. And so if you have operations in those states or have policies or other concerns about, the potential impact, you should really reach out to an attorney to make sure you're in a good place, especially in those states. Massachusetts, Washington, and DC, for example, have severe restrictions, and we're going to talk about DC in more detail in a second. But one of the things I want to note about these state-specific restrictions is that, again, while the FTC rule is very broad, and that's what we're faced with today, if it is struck down, these other state-specific restrictions are going to be just as important tomorrow as they are today. And so, again, it's very important that you know what the state-specific restrictions are in any state in which you operate, or even if employees are working remotely, how those states interpret remote work when it comes to non-competes, which is an issue that a lot of employers are facing more and more commonly today than maybe before the pandemic, because of the increase in remote work. In addition, if this FTC rule is struck down, we expect the state's trend to limit or ban non-compete agreements to continue, creating additional hurdles for employers who are seeking to protect their legitimate business interests through non-compete agreements. Next slide.
And just to expand on that for one more second, it just, as Kimberly alluded to, it's so important to just keep aware of what's going on in any states in which you have operations. Everyone or most people who know this area of the law know California has had this type of law for a long time. But again, as Kimberly said, the trend is continuing, and people might not know that Minnesota now has this law because it just went into effect about 6 or 8 months ago. I think it was, July of 2023 that it went into effect. So this could all of a sudden change without, big fanfare. And that completely, you need to do a 180 on what your practice might be. So you just need to, either be looking out for this or have legal counsel looking out for this to advise you on the changes to state laws in addition to the federal.
All right. So in DC, as I mentioned before, I was just going to not spend too much time, but just give you an overview of the more recent laws in DC. So in 2020, Washington, D.C. passed a law that significantly restricts an employer's ability to use a non-compete agreement, and that law took effect October 1st, 2022. Generally speaking, the new law prohibits employers from imposing non-competes on most DC employees who make under $150,000 per year, and employees who earn over $150,000, you may be able to meet some of the provisions and impose a limited non-compete, but there are a lot of notice requirements associated with that too. So if you are in DC, you have workers in DC, you've got operations in DC, it's very important that you have a lawyer advise you on existing non-compete agreements and whether or not you would desire to create new non-compete agreements, whether or not you can even do that. Because the law applies to a lot of employers operating in DC, and it covers employers who spend a lot of time in DC, which we all know people cross those borders from DC, Maryland, and Virginia quite often daily. An interesting feature of DC's law is that it prohibits a broader set of restrictive covenants than those that an employer may intuitively think about when they use the term non-competes. For example, it covers moonlighting. The Act prohibits an employer from restricting certain DC employees from performing work while employed, and could impact an employer's policies, such as like conflict of interest policies or policies that restricted a non-work activities during business hours, or non-work activities on the employer's premises or using an employer's provided devices. And those policies are quite common. It also includes anti-retaliation provisions. An employer in DC who has operations in DC, employees working in DC, they're strictly prohibited from retaliating against employees who refuse to agree or fail to comply with an impermissible non-compete provision or workplace policy. There's notice requirements within this law, and employers may face civil and administrative penalties for violating, but also aggrieved employees may have the opportunity to file an administrative complaint or file an individual lawsuit in civil court if they so choose to under this law as well, which is unique to the DC law. Next slide. So in short, the DC law is broad. I mentioned before that the law covers a broad group of restrictive covenants. However, the act is silent regarding whether employers in DC can continue to restrict post-termination solicitation. So that's the solicitation of an employer's customers, consultants, employees, and contractors. Now, I want to be clear about this. The law itself is silent to this. It appears that the law does not regulate non-solicitation agreements. However, there is no explicit carve-out for non-solicitation agreements. And the Act's definition of non-compete provisions is quite broad. It covers restrictions that prohibit employees from performing work or providing services for another person. So this is something to watch going forward to see how courts look and interpret this, especially when it comes to non-solicitation agreements. The law also doesn't apply to independent contractors, and it does not apply retroactively. Non-compete provisions in agreements and new agreements are affected in or after October 1st. And so that's important. Yeah, thank you, Jordan. You could go to the next slide. So I've been focused, as I mentioned before, on federal issues, and I want to really demonstrate how we got to, I'm sorry, the state issues, but I want to demonstrate how this progressed to the federal. So what we've seen thus far is restrictions in common law really grounded in state and local jurisdictional law. And in 2021, President Biden issued an executive order. And as part of that executive order, it prompted the FTC to propose new rules on non-competes. Essentially, it had directed the Federal Trade Commission to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. And until this point, again, very much grounded in state and local laws, but we start to move from the state and local jurisdiction to much broader restrictions, potential restrictions that may impact the entire country. In 2023, the National Labor Relations Board got into the discussion, and on May 30th, 2023, the NLRB issued a memorandum in which the General Counsel took the position that, except in limited circumstances, the proffer, maintenance, and enforcement of non-compete provisions may violate the National Labor Relations Act. So there's two particular provisions of the National Labor Relations Act that are the focus here. One is Section 7, which protects employees' rights to take collective action to improve their working conditions and applies to most private sector employers and employees. Section 8 of the Act prohibits employers from restraining covered employees, Section 7 Act. So in layman's terms, to take these two things, these two sections together, the NLRB argues that non-compete agreements can have a chilling effect on protected concerted activity of employees. So what does this really mean? So for example, if employees wanted to get together and threaten to resign and take their skills to another employer if their current employer does not provide them better working conditions. So I want you to provide us with better health and safety conditions. And if you don't do so, we're all going to quit and we're going to go to a competing employer and take our skills elsewhere. Those are the type of things that the NLRB was most concerned about. I want to point out here, though, that this memorandum in and of itself reflects the General Counsel's interpretation of the law and an aggressive enforcement approach, but it is not in and of itself legally binding precedent. But what we're going to get to next is what is potentially a legally binding precedent, which is the FTC's proposed rule. So I'll give you an overview of the proposed rule briefly, and then I'll hand it over to Jordan to talk to you about where we are today. So in 2023, the FTC proposed this broad rule prohibiting employers nationwide from entering into non-competes. And they took the position that non-compete agreements constitute unfair method of competition under the FTC Act and stifled competition, essentially, resulting in reduced wages and suppression of mobility. And it is important to note too, and Jordan is going to highlight this, that there are questions about whether the FTC has legal authority to promulgate this rule. So setting aside the legal authority, though, the rule was, like I said, very broad, and it covered a lot of workers, including independent contractors and senior executives. And it was more broad and restrictive than a lot of, if not all, of the state and local laws, including Washington, D.C.'s. So it covered interns, for example, and volunteers, and it forced employers to withdraw any existing non-competes. It also made it unlawful for an employer to enter into a non-compete with an agreement or attempt to enter into one with an employee. So it was quite broad. Now, there were some exceptions, but these were not as broad as they needed to be. So the restrictions were quite broad, but the carve-outs were not. And this is one example of the carve-out. And it provided an exception for non-competes between buyers and sellers when you've got the sale of a company. But the exception would only apply to non-compete agreements where an owner, member, or partner held at least 25% interest in the business. And that's not nearly as broad as it should be. Next slide. So ComICL represented a diverse coalition of employers, and we do this not just for this proposed regulation, but for other proposed regulations. So if you hear of a proposed labor, employment, health, safety regulation that causes you significant concern, please check in with one of our attorneys, because we may have a coalition set up so that we can collect comments and submit them to the agency without necessarily attaching your employer's name to them, and let your voice be heard. So we represented a diverse coalition of employers that were rightfully concerned about the potential impact of this law. And our firm submitted these comments to the FTC to really try to help them develop and promulgate a rule that both protects employees from potentially unfair non-competes, while at the same time protecting employers' legitimate business interests. And our comments focused on three main recommendations. One, broadening that sales exemption. Two, excluding highly paid employees, executives, highly skilled employees, those employees that really go back to the essence of what non-compete agreements were really set up for. And we encourage them or urge them not to apply this rule retroactively. In other words, the proposed rules should require employers to rescind it should not require employers to rescind all existing agreements. Essentially, it should apply only to new agreements. That's what we urge the agency to do. And just to know that the agency received thousands of comments. I want to say it was upwards of 20,000 comments on this. So there were a lot of employers who were rightfully concerned. And with that being said, I will turn it over to Jordan to tell you where we are now.
Thank you very much, Kimberly. And feel free to jump in if you have anything to say, throughout my presentation, given your knowledge of everything. But I'll pick up right where Kimberly left off and say, yeah, the FTC received 26,000 comments, and I'm not bold enough to say that they definitely paid attention to our comments. I don't even know if they read our comments, but we did accomplish some, if not most, of what we set out to accomplish, and I will talk about that for the next few minutes. But the sales exemption we got 100% as we wanted, and we got kind of a combination of the retroactive and senior executive exemption. And for those of you that don't know what I'm talking about, I will, do my best to explain it right now. Less than a month ago, so this just happened. I was actually in a labor and employment conference when this occurred. In a very close vote, although we knew based on political leanings what the score was going to be. The FTC approved and then released this final rule. It largely tracks the proposed rule, but there are a few exceptions, which we will explain. But essentially, the preamble basically states that the FTC believes and has determined through its research and all its methods of investigating, including reading the comments, that non-competes constitute an unfair method of competition. And as a result, it violates a portion of the FTC Act. And these words, unfair method of competition, are also what a lot of the legal challenges are to the FTC's authority are going to say, where essentially the FTC doesn't have the authority to determine what is or is not an unfair method of competition. A non-compete clause, they really say it means what it says. It's any contract term that restricts a worker from joining a competitor or starting a competing business or doing anything after their employment ends that could remotely be considered competitive and or infringe on the employee's right or the former worker's right to earn a living. And I just changed the word there. I caught myself to say workers instead of employees, because as with the proposed rule, and as Kimberly mentioned, as is different from almost every other state, this includes employees, it includes independent contractors, it includes interns, it includes volunteers. So, it's extremely broad. I've often advised companies not to have non-competes with independent contractors because that could potentially point to an employee-employer relationship. But I also didn't, think before then that they would per se be unlawful, but that is where we are right now. So not only does the FTC rule prohibit an employer from entering into a non-compete, it prohibits you from trying to enter into a non-compete, from enforcing or trying or attempting to enforce a non-compete, or representing that a worker is subject to a non-compete clause. And where this gets into, it comes into play a lot, it is, as many of you probably know, throughout the years, if an employer had an employee who left and we arguably thought they'd be competing, we would send, what's called a cease and desist letter, basically to say, we've heard that you may be taking a competitive job, please be advised that you are subject to a non-compete. And quite frankly, sometimes employers would send that even if their non-compete was overly broad or may not have been enforceable, kind of just to scare the former employee from taking an arguably competitive job. And I think, that is the type of thing that the FTC wants to avoid. So it won't be a defense under this law to say, well, we sent a cease and desist letter, but eventually through litigation, it was determined that the non-compete was null and void. You as an employer could still be found to be violative of this law. It supersedes all state laws that are in conflict with the rule. So, this of course is broader than most states. So it will supersede the broad part of those state laws. But for example, in DC, as Kimberly mentioned, DC has an anti-moonlighting provision. The FTC rule does not. But although there's no case law on this, it is my understanding that if you're in DC, this broad non-compete law will apply, this FTC law, but the DC portion of the law will still apply that has the anti-moonlighting provision. So it's to the benefit of the employees in both situations. Yeah, as an employer, you can't choose which parts to abide by. Something like California. If you're in California, essentially that state law and this FTC law are pretty similar. There'll be some small minor differences, but for the most part, you just have to assume that the more stringent law applies. There are a few exceptions that I'll talk about in the next few slides with senior executives and the bona fide sale of the business. But essentially, issuing a non-compete or otherwise failing to comply with the rule in the ways I just mentioned would be considered a violation of the act and would result in fines and penalties, certainly in injunctive relief. So assuming this rule stays, that is something you won't want to mess with. But let's talk about the senior executive exception. In our proposed comments, we said the rule shouldn't be retroactive for anyone. And also the rule should carve out high-level senior executives. In the FTC's final rule, they combined our two requests. So the FTC's rule is retroactive for all employees other than senior executives. So the rule says it is not an unfair competition to enforce or attempt to enforce a non-compete clause entered into before the effective date of the final rule, or to, as we mentioned earlier, to represent that the senior executive is subject to a non-compete clause. So assuming you have a non-compete with a senior executive that you signed yesterday, and it's a 2-year non-compete, that non-compete should be valid for the next 2 years. Likewise, if you had it a year ago and it's valid for 1 more year, it should be valid for 1 more year. You even could sign one now or sign one up until September 4th, and it will be valid for as long as it's in effect. Of course, a senior executive might be attuned to what's going on and not want to sign something in the next few months. But, keep in mind that this rule, although it's quote unquote a final rule, it's not effective yet. It's not effective. I believe the date is September 4th. And then the question becomes, who is a senior executive? And the first part is easy. It's a salary threshold test. It's a very strange salary. I quite frankly am not sure how they came up with this number. They must have had some formula. But the person must earn at least $151,164 in the preceding year to be considered a senior executive. He can't just raise his salary now and then say, or her salary now and say he or she is a senior executive. And the person must be in a policy making position. We can talk about this, in more detail if you have any questions. Essentially, it's a entity's president, CEO, or equivalent, an officer of a business or a person who has final authority to make policy decisions that control significant aspects of a business. If they just have authority to control a part of the business, that probably would not even cut it. So, senior executive is really what it says. As I said, CFO, COO, CEO, just, mid or even a high level manager at your company, even if they make over 151, likely will not cut it. Although I could see this being the subject of litigation going forward. There are a few other exemptions. The FTC does not have authority over nonprofit organizations, so the FTC's rule does not apply to nonprofits. The FTC rule also clarifies that a worker with whom the rule restricts or bans non-compete agreements does not include a franchisee in the context of a franchisee-franchisor relationship. However, the final rule does apply to non-competes with a person who works for a franchisor or a franchisee. As with the proposed rule, the final rule does contain an exception that allows non-competes in connection with what's called a bona fide sale of a business. But as Kimberly explained in the proposed rule, it said you needed to own 25% of the business, or you could not have a non-compete in this context. So arguably, if you had 5 owners all are owning an equal portion of the business, non-compete would not be possible. Now you do not need to be a substantial owner to qualify for this exception. So for the most part, if you're selling a business, you should be able to enter into a non-compete. There's now a notice provision that's different than the proposed rule. And I saw there was a question about this a few minutes ago, so I'll address that. Under the proposed rule, an employer would have been required to go and rescind every single non-compete clause that existed. So if you had hundreds and hundreds of non-competes, there just would have been an absolute ton of logistical and administrative work to actually rescind the notice. Now, workers with existing non-compete clauses, it's the same effect, but they simply must be provided with a clear and conspicuous notice by September 4th that their non-compete clause is no longer legal and cannot be legally enforced against the worker. In the final rule, there is a link you can click on that then takes you to the FTC website that provides model language on how, so an employer does not have to use that language, but if they do, that provides you with a safe harbor that you can always defend yourself, saying that you provided the notice exactly as was set forth by the FTC. But to answer the question that was asked, let's say you're a proactive employer and you think you don't want to be on the hook for fines and penalties. You want to be a good law-abiding corporate citizen. Should you send out the notice now? And then what happens if the rule gets gets enjoined or overturned or what have you? And I would urge you not to send out any sort of notice now. We need to wait and see how the legal all the legal procedures and legal challenges, and there's just going to be a whole lot of legal stuff, for lack of a better word, going on the next few months. If by mid to late August, there's still no movement and it really looks like the rule is going to be going into effect as is, then you send out the notice. But it's really not going to do you any good to send out the notice now. So that's, quite frankly, we typically give different types of advice. We would typically advise, hey, there's a new rule that's in effect. Let's be proactive. Let's, start sending out the notice. But it's not often that new rules that are implemented are such, again, there were 26,000 comments that were written. There's not always such vehement passionate arguments on both sides and such strong legal challenges. So here it's going to be a little bit more of a wait and see what happens. But just so you know, and this was something we also actually talked about in our comments, the final rule does not prohibit enforcement of non-competes, that were accrued prior to the effective date. Of course, let's say for senior executives. So pending litigation should not be effective. Of course, if you're trying to enforce a non-compete with a senior executive or after the effective date, that will invite all sorts of litigation. But actual litigation that's going on right now about whether or not a non-compete is valid, that argument, those legal arguments are about rules that were that were in place prior to now. And this new rule does not just void out all that litigation. So, if you are suing someone who have already breached their non-compete, you don't have to all of a sudden just drop that lawsuit. Other restrictive covenants, this is a little bit of an open question, but for the most part, they're largely unaffected. They may be effective, but they're largely unaffected. Specifically, garden leave, and I'll talk about that a little bit more in a couple minutes with the last few minutes I have left. And similar type arrangements should not be considered a non-compete clause under the final rule, especially if the worker remains employed during the relevant time period. The final rule specifically states that it does not consider it to be a non-compete agreement if the agreement imposes no restrictions on where the worker may work following employment. So for that reason, an agreement not to solicit your company's employees or not to solicit your company's customers should not be prohibited by the final rule. But if it's extremely onerous and, basically you're not allowed to talk to anyone and you have a new job that's essentially going to, that this non-solicit will function to prevent you from working at your new job and competing, it's possible that the non-solicit agreement will be found to be unlawful. So that's something you just need to keep in mind. But for the most part, general non-solicits should be okay. I think I mentioned earlier that the final rule does not extend to restraints on concurrent employment. So you are allowed to prohibit someone from competing with you while they're employed. It's just after they're employed that you're not allowed to insist that they abide by any sort of non-compete agreement. So, just if you're thinking about this and you get confused, just remember that the FTC rule, think of the T as termination. The FTC rule applies to agreements that have happened post-termination. Now let's talk for a few minutes, and I don't want to get too bogged down into the details here, but there are a bunch of challenges to the FTC's final rule. Largely, I'm just going to say that the U.S. Chamber of Commerce is leading the challenge. They actually filed a second lawsuit, I believe, and there's another lawsuit that is proceeding first, but the FTC is essentially joining that lawsuit. And what they are saying is essentially that and remember I mentioned this earlier about the unfair methods of competition. They are saying that the FTC lacks the authority to issue regulations that prohibit unfair methods of competition. And this is referred to as the major questions doctrine. And what that is a rule of constitutional interpretation that holds that when delegating rulemaking authority to agencies on questions of large economic and political significance, Congress must provide clear and direct authority to the agency to do so. and the court will not just defer to an agency's interpretation of its own enabling statute. And for this reason, I believe, it was a couple of years ago, Congress struck down a law that the EPA tried to set forth in a some similar way to what the FTC is doing now. And a combination argument to that is that this rulemaking is an impermissible delegation of authority. And the Constitution provides that all legislative powers should be vested in Congress, and it's Congress who has this authority, and they can't transfer this power to an agency. So that's kind of the nuts and bolts of the legal argument. Of course, then they're also going to argue that workers will suffer from decreased training opportunities and bargaining power, and startups might face threats from larger companies. And as a result, they maybe have difficulty, obtaining access to confidential information or losing such access. But it's really going to be the legal challenges. And as of now, we don't have a ruling. There were lawsuits that were filed, and then there were injunctions that were sought. Essentially, the FTC is trying to get the court to stay this rule and basically say, for now, the rule shouldn't apply. It should be status quo as before the final rule until the lawsuits play out. The smart money is on the FTC, on the Chamber of Commerce winning at least some part of their lawsuit and injunction being joined, but we certainly don't know that. That's just my prediction and others' predictions, but we're really not sure. So what I want to get to here at the end is just what to do in the interim. We're not going to get to what you should do pre and post hiring of non-competes. I thought we might not get to that. That has not changed from before. So that's something, if you have any questions, you can reach out to Kimberly or me, and we'd be happy to speak to you about that. But just until now, for now, we have some, key bullet points here. Take account of your existing non-compete agreements and, assess, would they comply with the final rule? Most likely they wouldn't. Maybe your senior executives would, at least up until September 4th. But you need to understand what action might be necessary prior to September 4th. Will you need to file that, send out that notice that we talked about? Again, you're not going to do that today, but you need to kind of take inventory of what you have. Then figure out what could you do that could be something that could similarly protect you, but not be a non-compete. Should you have these workers sign non-disclosure agreements or confidentiality agreements, both of which should be lawful? Should you have non-solicitation of customers' employees? Again, you want to utilize counsel and make sure that if you do those, they're not so onerous that they could be found to be within the realm of the final rule. But basically, you want to review your policies and procedures to make sure you have mechanisms in place to protect confidential information and trade secrets, and audit such policies to confirm that only necessary employees retain such information and that such information is properly secured, especially given that you can't necessarily tie employers to you any longer. It is also recommended that any employee manual be included in a policy review, because sometimes employee handbooks and manuals contain non-compete policies, sometimes they don't. And you should see whether or not you need to change or amend the applicable provisions in your employee handbook if they relate to non-competes. One thing you might really want to do is think about providing garden leave. If you guys don't know what that is, you could talk to us in further detail, but it's essentially telling someone you're not prohibited from competing, but for the next 6 months, you're gonna stay on our payroll. We're gonna let you hang out on the beach. So you're not gonna go to a competitor, but you are still getting paid. Obviously you're not going to be jumping for joy about that, but at least that might be more preferable than having someone go to an employer, depending on, you know, what information you're trying to protect. And of course, the employee still should not be able to take trade secrets with them. But if the employee, just by leaving, is so potentially so damaging to you, you really want to consider garden leave, in addition to what I mentioned, non-solicitations, non-disclosure agreements, and things of that nature. As I said, I'm going to skip over this last section and just leave up here all of our other employment webinar series topics, so you can look at them and see which other ones you want to join in the future. I want to mention, if you're a California employer and you don't have a mechanism in place for the workplace violence prevention rule that's coming up in July, you want to talk to someone in our firm about those issues. And we have all these blogs that you can check out where we love to talk about all these issues. And let me see if there's any other questions. Oh, thank you. Someone let me know that the senior executive salary number is the 85th percentile of all full-time salary workers nationwide. So I did not realize that. That's where the 151,654 number came from, if I have that number correctly. And on that note, on behalf of Kimberly and myself, I'm going to say thank you very much for joining us today. We really enjoyed presenting on this topic.
Thank you. Have a great day.